Okay. Oh, so we're at the top of the hour. We're just having a very spirited conversation about retirement communities, which Scott claims he's not quite mature enough for yet. So, but
I'm
we'll
almost
give
there.
this a few minutes as you're getting close. Yeah, I got my ARP mail the other day, so I tore it up. Let the audience filter in here for a little bit, and then we'll get this thing going. Start at 2 after the hour. And just like that, the dog starts barking. Okay. Get my Q&A button loaded, so I'm ready for all the questions that will come in. All right, let's get the introductions in motion anyways. Danielle, if you want to click ahead to the next slide, we'll get there. But joining us today will be Christine Cooper. She has been a guest with us at one of our symposiums. Did a phenomenal job, and she's done a fireside chat. I think it was last year, perhaps. Feedback's always been great, so you guys are in for a good treat here with her and her knowledge around all things legal and the programs that her organization has built and how they've been incorporated into what has become one of the primary products that 6 Degrees sells today. So very pleased to welcome Christine Cooper to the Fireside Chat series. Also, and not to be forgotten, is the founder of 6 Degrees, Scott Ray. Also not ready for ARP yet, so he's young. He's young and vibrant, as we discovered this morning. I think he compared himself to a 4th grader, so he's got lots of spirit. As always, we will be keeping somewhat of a casual vibe to this, but try not to do too many slides. We'll be going through the content, but we welcome all the questions that you might have as we're sitting in this. At the bottom of your screen is a Q&A button. Click on that, and if you could ask your questions through the Q&A function, that makes my life a heck of a lot easier as far as keeping track of the questions that come in. Some of you guys like to cheat and bypass that system and use the chat function. I still typically read those off, but in the back of my mind, I'm thinking bad thoughts. So use the Q&A, please. I really appreciate it. With that, Christine, take it away.
Sure. If you want to jump to the first slide, or I guess the second slide. Just a little background. I have been handling healthcare litigation now for quite a few years, and in particular with reference-based pricing plans, and working with the MediShield product now as well with 6 Degrees. It's been a great experience, and it's a fun space to work in the healthcare space. So the first slide we have here is really just outlining some of the common reference-based pricing concerns that we hear. And later on, we'll get to how we address each one of these in turn and talk about a few other ones that pop up along the way. So these are the main ones. We get here concerns about, am I going to be balance billed? What does balance billing look like? I'm going to collections. What does that mean? Is this for sure going to end up on my credit report? And then am I going to be sued? There are some other tactics I want to raise that less frequently happen, and also talk about how we deal with those. So next slide. So the first one, balance billing. I put some statistics on here so you all could get a feel for really the incidence of balance billing across all of the bills. The incidence or the range that we hear industry-wide is about 3 to 5%. That's the average experience. 6 Degrees, however, their experience has been about 1.5%. which is really, really a fabulous number. So of all the claims that are processed, it's a very small percentage that are actually being balance billed. What we see is certain providers more routinely balance billing. It's rare that we're seeing a new provider that has started balance billing. So there are many that will accept reference-based pricing. And then we sort of categorize the balance billing as aggressive to not so aggressive, or vice versa. It is a low percentage, but we understand that noise comes with even a small percentage of balance bills. So I thought I would outline a few, let me walk through how we handle these balance bills. So when they get referred to our office, we assign a lawyer to the bill. We have paralegals that work on these bills, customer service representatives who are reaching out to both who our client is, which is the plan participant, as well as to the providers themselves. And we start disputing the bill. Our grounds for disputing the bill are primarily that the charges are unreasonable, and well above the Medicare percentage that would allow them to have some profit margin built into it. Ultimately, the way we've structured the representation is to represent the plan participant, because that gives us a lot of clout with the provider. They know when we get involved that we're handling each individual bill as an individual bill on behalf of that member. And so it gives us a great opportunity to say, hey, this member is not going to pay you any more money. They either don't have the money, shouldn't have to pay the money, you're going to have a hard time collecting from them, and they have a lawyer. So, that's going to be, just yet another hurdle for this provider to get through. Some of our success in handling that balance billing, we have been seeing more and more affirmative write-offs as we have developed more and more relationships with these providers. I call our relationship with the provider friendly aggressive. We don't yell, we don't scream at them, we don't get nasty with them. We want to know what's going on in their world. It helps us. It helps us settle these claims. It helps us get the write-offs that we're starting to see. So I put a big and a small on here because I think a lot of people want to focus on the large bills because it is a huge dollar value savings, but the little bills are every bit as important. So recently we had a $343,000 affirmative write-off down in Texas with a provider down in Texas. And we also had a $3,500 write-off up in Oregon. So what does that mean? What is an affirmative write-off? That means the provider sent out a $0 balance bill and completely wrote off the bill, made an adjustment in writing. That's what we call an affirmative write-off. That, in my world, in our world, is the greatest success we can have in defending a balance bill, is getting that type of affirmative write-off. Once we get one once, we're more likely to get them in the future. And ultimately, those providers become really reference-based pricing friendly for the plan participants. So that's a little background. Yes.
I have a little question, and this is not pre-scripted for the audience. I don't know the answer to this really. I'm just curious, when you guys do connect with a hospital, do you find that the case gets escalated to a different representative in the hospital because the patient is represented by a lawyer?
It depends on the system. The smaller systems may not have as much escalation ability as the larger systems. One thing that we focus on trying to do is get a good contact at the various providers. And it may be someone in the billing department. It may be someone in in-house counsel's department. There's different providers are structured differently. And so really what we're looking for is that best contact. And it really could be anyone in the financial side of it. We tend to get a lot more information out of the billing department because obviously lawyers are a little more, keep things confidential, keep things closed up. So I would say we sort of attack it from a variety of different fronts, but getting a person who's been around a while, knows the provider, is really where we see a lot of success and where we try to develop those relationships. If you go too low of a level, you get a lot of turnover and, they're just sticking to a script. So we don't want that either.
Yep. Okay, thanks.
So balance billing, obviously something that happens with reference-based pricing. It's pretty low noise when it's just a bill from a provider. It's, you know, something that I think we should expect to deal with and have plenty of ways to deal with that in sort of a quiet manner. One of the things that we also do with the balance billing and everything else, we communicate a lot with the plan participant. It's really important for them to know what's going on so that they can ask questions. They have, you know, the current status of where their bill is and what's going on with it. It, you know, tends to calm them down and bring a lot more certainty and clarity to the process. So that's important too. If we want to go to the next slide. Okay, so now we're getting into the things that cause a little bit more, you know, issues for, I'll say, concerns, that the plan participants have more concerns, and those concerns are then passed on to their HR departments and so on and so forth. So collections, the process. Often, you know, a provider uses a particular collection company that they will send their bill to. Collections is not, in my world, it's not scary. It's a continuation of the balance billing process. There's only so much bandwidth that a provider has to try to collect these bills over time. So what they do, they don't sell the debt, or they rarely sell the debt, I guess I should say. They rarely sell the debt, but what they're doing is basically handing the bills over to a collection firm who then collects and gets a percentage of whatever they're collecting for that provider. With respect to collections, I have not seen a new collections firm in several years. So we have built, I'll say again, a friendly, aggressive relationship with the medical debt collection firms that are out there. We know their processes, we track their processes. We're able to provide a lot of certainty to the plan participant as to what's going to happen with their bill through collections, how long the process may take to get it resolved, you know, where we might be able to settle, what percentage is the settlement going to look like, and so on and so forth. But it is not unusual for a balance bill to be sent to a debt collector. The process there is very similar for us. We communicate with the agency. Once an attorney gets involved, and this is the distinction between working with a provider, dealing with a provider, and dealing with a collection agency. Once an attorney gets involved in the collection process, that collection agency can no longer communicate with the plan participant. If they do, that is a Fair Debt Collection Practices Act violation, and usually some state laws too. And they know that, and they don't want to be, you know, in violation of their collection laws that they have to know very, very well. So having legal counsel for that member is really important to handle this collection component of it. It really does insulate and protect that plan participant, and it reduces the noise coming from them because they're not getting those collection notices. They're not getting harassing phone calls. They're, you know, anything like that has ceased as soon as the collection agency knows there's an attorney that's representing that member. Some successes that we've had recently with collections, there are agencies now who we've dealt with for years who immediately send that bill back to the provider. So they're not even willing to attempt to collect. It goes out of collections almost immediately, and back to the provider to collect if they're, you know, to attempt to collect if they're so inclined to do so. That's a huge success for us and for the member, because now they're not in collections anymore. So, you know, it's one less individual involved in the process. I think it's indicative of the fact that when a lawyer is involved and these collection agencies know they're not going to get the funds, it's not worth their time and energy and effort to try to continue to collect. You know, what they're after is a quick payment, a quick settlement, you know, something to really line their pockets, and then feedback to the provider. So we are seeing more of this happen as well as, you know, time is going on. These collection agencies want faster recovery. An attorney gets involved, it messes things up for them, and they're referring these claims back to the provider, where we then have to, you know, we're negotiating with the provider, we're talking to the provider to try to resolve these bills as opposed to the collection agency.
Christine, yes. On the one point, you kind of touched on this, but I just wanted to emphasize it. You know, one of the benefits of of debt being turned over to a collection agency is it does trigger some additional protections at the federal level for the patient. So that's a positive side of this,
Mhm.
right? And then there are some states that afford some of these additional protections to against the original creditor. Is that true?
So there are consumer practices acts. The various states have different ones. There is a uniform act, and if the collection agency runs afoul of that, it could be the original debt holder, which would be the provider. More often, there's more protections for an individual at the collection level than there is if the provider is still attempting to collect the debt. The original debt holder can get away with more. So, as an example,
Yeah.
it's rare that a provider has to stop calling a plan participant. Now, we request that because they're dealing with us, and most providers will respect that request, but
Yep.
they're not under the exact same obligation. However, what they are under is, they can't use fraudulent tactics. They can't, threaten litigation if they're not going to litigate. I mean, these are general state. This is not federal, isn't necessarily applying to them, but there's state laws that are similar that would apply.
Yeah.
Interestingly, even under the federal, might be going a little too legal, but even at the federal level, there are occasions in which an original creditor, like a health provider, could be on the hook under these federal rules. It's rare that they step in that. We do look for it. It could be having a third party, a third party billing company that they own, that it's not clear that it's coming from the provider. So they've essentially made themselves a collection agency subject to the rules. We do see that happen every once in a while.
Okay, interesting.
Christine, there's a couple of questions that came in. So as long as we got
Yes.
kind of a disrupted pause here, let's get those before we get too far down the road. One came in from Brandon. Do you have any materials on the success of RBP from state to state, those that are in RBP friendly and those to avoid? So I'll give the 6 degrees answer, and then I know you've got some states that, or at least general locations, that have been somewhat problematic with the legal component of this. So 6 degrees, if you're using us, we can do an analysis and a disruption report and give you a pretty good idea in terms of the different strategies you might want to take based on the location you're in. There's usually a way to do RBP in most locations. Sometimes that involves a reference-based contracting approach, or cautionary footsteps in terms of how you're going to pick your providers in those locations. But we can give you a pretty good view as to what to expect from historical success rates. One thing to keep in mind, though, is if you're doing true reference-based pricing, because if they were accepting it yesterday, it doesn't guarantee you that they're going to accept it tomorrow. I mean, you can see trends, and the same can be in the inverse as well. You may have a problematic provider today, they change CFOs, and they're all about it next week. So that is the one cautionary thing I would say about reference base, is that there can be changes in policies in the way that they accept or don't accept, because it is not a contracted approach. But historically, you don't see major reversals overnight. But with that, I'll turn it to Christine to kind of answer it from a legal perspective in terms of what you've seen in balance bill resolution when you guys take them on.
So we're not seeing necessarily a state by state type issue. We see a provider by provider issue. And so one of the things that we do, we have a database where we track all of this information, and we can go back and look and say, okay, this provider gives trouble, or here's what this provider is doing. Maybe this is an issue for the plan, maybe it's not. Where we see the most difficulty, I would say, is in rural areas that have one provider that may use some niche state law to try to attack these bills. I think we are also seeing right now a changing landscape in state law that's slowly, state by state, is making it more challenging for providers to seek to collect these debts or use the tactics that they've used in the past. So I think we're going to almost see, we could potentially see a softening of this as we go forward. But I would say, to answer the question directly, I don't look at it state by state. I really look at it provider by provider, and who's difficult and what is the pain point that they seem to be raising.
Yeah, good point, Christine, on the provider to provider. The other thing I would add to that is that as you have these conversations with the employer, some states are going to generate larger savings than others just based on billing practices, and same for providers. That they're billing higher, your savings are going to be greater, and sometimes that makes it worth the potential disruption or obstacles that you have to navigate around in that first year. So all things to consider, things we can talk through with you as you take this approach and decide if it's something you want to do or if it's the right employer for this solution. Okay, Christine, are the write-offs also relevant to profit or nonprofit hospitals?
Both. It's both. So it's, it's pertinent for them to sometimes get these debts off their books, right? At the end of the year, maybe we'll see a higher uptick in write-offs, although we've been seeing it depends on their fiscal year, but we're seeing it throughout the year all of a sudden. I would say it's not limited to anyone in particular. It's both the for-profit and nonprofit. We're seeing affirmative write-offs. It could be an emergency center. It could be, an anesthesiologist office. So it's not even necessarily limited just to facilities. It's kind of across the board. And I don't know that there is a public policy or a policy reason for what's happening. I think it's probably more a business decision. They don't, they're not going to collect. They know they're not going to collect. They get an advantage from writing it off. I'm guessing. I will say, though, a little bit, I'm guessing on what the provider's thought process might be on it.
I've heard also, and I'm not an expert in this area, but I've heard that it's not uncommon that hospital finance execs compensation packages can be tied to accounts receivable aging. And so, there's maybe some disincentive for debt to be sitting on the AR for extended periods of time.
Which would make sense. If you think you could collect it, then you might as well leave it there. If you don't, then get rid of it as soon as you can.
Hey, Scott, here's one that came in, and I'll let you navigate this. I know that we do some of this work with a few of our clients. Does 6 Degrees incorporate 501R?
Yeah, so 501R is the if the patient falls under a certain income level, there's some protections afforded to them. I think it's through the ACA, but Christine's more of an expert on this. And we do have some plans that will utilize services that try to identify those opportunities and take advantage of them. And we've gotten involved in some on an ad hoc basis. So it's been around for a long time, and longer than we've been in reference-based pricing. It's never really taken off, and I have some theories on why that is. I think part of it is, maybe a reluctance on behalf of employers to, be highlighting to employees that they fall under the federal poverty limit or something of that sort. It could be basically saying, hey, we don't pay you very well. So there could be some benefits here for you. It's also challenging just to get the information because it's financial information about the patient's family, and that's often not possessed by the plan. And so there's some hurdles there. But I don't know, Christine, do you guys ever get involved in that much?
So it's rare that we would do that. And there's a couple of reasons from our perspective why we encourage our clients not to utilize that process. One, each provider by provider as to what the poverty level, not what the poverty level is, but what their financial assistance is going to be above that poverty level. But to your point, Scott, there's so much financial information that they collect from the plan participant that from a legal perspective, it's almost like giving them a roadmap to be able to collect. It gives them bank account information, it gives them all that kind of stuff. So we like to deter that. The additional reason is our grounds aren't that the members can't pay, it's that the bill is unreasonable. And so we don't want to start creating an expectation from the provider that they're going to get this information, that this is the reason that that they should be writing off certain amount of this debt. And it can put the member in a bind, because then they're actually signing a contract either to reduce the payment and agree to pay whatever's remaining, because it's not 100% write-off necessarily. It could be a 50% reduction or a 25% reduction off of an unreasonable amount. So we know it's out there. We occasionally will do it if a member, obviously they're a client, and we advise them that this is for certain ones is a possibility. Most do not want to participate in that process.
Yeah, that's great insight.
Any other?
That's all the questions currently. Yeah.
Great. So to sort of get back to the collections just for a moment, some of the other, we really do use those federal laws to our advantage to get claims settled or written off. Our attorneys are always looking for Fair Debt Collection Practices Act violations. It could be as simple as sending an additional letter to the member once they know that the members or should know the member is represented by an attorney. That member could then sue under the FDCPA to collect. It's a small fee for that violation. I think it's about $1,500. We aren't suing, but they know that that's a possibility, and they don't want to. Those collection agencies don't want to have that on their record. So we'll utilize those violations as an opportunity either to get a really reduced settlement or a write. Obviously, we start with a write-off first. So it's looking for those, having a lawyer look for those. Same with like Fair Credit Reporting Act, some egregious state violations. We don't see those as often. Most often they get tripped up by the Fair Debt Collection Practices Act. So for the collection purposes, we utilize that to our benefit as well. Next slide. So credit reporting. This is one that I think there's a lot of misconception around with the plan participants that we speak to initially. And oftentimes they think if their bill is sent to a collection agency, it's going to immediately be reported to the credit bureaus. That is not the case. In fact, the incidence of credit reporting, and this is members telling us or plan participants telling us that they have a derogatory mark on their credit report, only 0.3% of MediShield participants have experienced a reporting incident. And so, and those are claims referred to us. So if you think about the greater world of claims, I don't know what that percentage would be, but it would be, incredibly small. But we know it's important. We know it's important for those members that do happen to have a derogatory mark on their credit as a result of a bill. We have created a credit repair process. It takes working with the member. They have to send us certain information and we complete an application that we send out to the credit bureaus to get the mark removed. At a minimum, the mark would state -disputed, but we roughly 40% of the time can get the mark removed in its entirety. We're seeing now also legislation that's changing the credit reporting methods, timing, amounts. So for example, the 3 major credit bureaus no longer report debt under $500, medical debt under $500, which is huge because most of the medical debt that gets reported are the small bills, because the collection agencies know if they do that, they can collect $250 from, a patient. So that has been a big step from a legislative standpoint. There are state laws now that are also updating and changing. New York, no medical debt can be reported anymore. In Colorado, you can only report it if, and I don't know how they would know this, but this is the new law out there. It can only be reported if the person is seeking a loan in excess of $766,000. So I'm not really sure from a technical standpoint how that all works, but presumably if you can afford $766,000, they probably think you can afford to pay whatever medical bill comes in. So this is an area that I think there is that we hear a lot of concern about, but that there are ways to address it. And a lot of open communication with that plan participant is key in addressing it, because there's processes for the credit reporting agencies. We can go back to, we demand from the collection agencies that this that be removed from the credit. We ask that it not be reported while we're negotiating. So there's steps we can take. One other thing, if it is on their report, sometimes they don't find out until they're trying to qualify for a loan. We then get involved with that loan process. We write letters to the bank, and whoever the bank directs us to write letters to. I've been on phone calls with them so that we can explain what the mark is. To my knowledge, we have never had anybody turned away for a refinance on a home or a car loan. Those are the two where it most frequently comes up. So while it can seem scary, there are methods to deal with it, and I think this just goes to having the importance of communication with all these different players that come into the mix on it. One other thing I'll say on the credit reporting laws by state. Florida is now jumping into it. They're waiting for DeSantis to sign the law, but it would not permit extraordinary collection activities until certain benchmarks are hit by the provider, including providing an itemized statement. They can't do it while the bill is in active and good faith negotiation, which I think is key for any plans that do negotiate these bills. So that's not signed yet, but it unanimously passed their House and their Senate. So the likelihood that it doesn't get signed seems pretty small. Next slide. Litigation. So litigation is the other concern we hear. Am I going to be sued? The incidence of litigation is small as well. So of the claims referred to us, less than 1.5% of MediShield participants are actively in litigation. The next metrics you're going to see are success rates with litigation, and I'll talk a little about our approach to it in a moment. These are across our entire block, but 99.8% of cases are resolved prior to trial, and more than 80% are dismissed with no further payment. So we're not even settling those. What's happening is these providers and collection agencies are using attorneys that are typically on a contingency fee basis. When we get involved, we're lawyers, so what I would say, lawyer up, and we're serving discovery. We're asking for a lot of information from them. We take the small bills on up to the large bills. We request a jury trial. I'll say we make it difficult, but really we're utilizing all the tools available when a lawsuit is filed to defend these, and we vigorously defend them. And the plan participants deserve that. They don't, these bills are unreasonable. And so, by representing that plan participant, one, you're representing the plan participant against, say the Cleveland Clinic or somebody big. So, they know they're not going to fare well in front of a jury in that situation. So having a lawyer involved in that process is really important. What those collection agencies, I guess the lowest hanging fruit the collection agencies are looking for is an unrepresented plan participant who they can sue, get a default judgment without anyone ever walking into court. That doesn't happen when we're involved. And in fact, we use all the protections afforded to these plan participants under the rules to be able to get these cases to be resolved. But again, it's a very small portion of these claims that are ending up in litigation, but important for them to have that defense. Some states are taking action. Again, Florida and Colorado, part of this Live Healthy Act that is likely to go into effect would lower. There's only so much time an agency or provider can bring a claim. Some states it's 8 years, some states it's 10 years. Florida's limiting it to 3 years. Colorado has lowered the amount of interest that can be collected on these judgments from 8% to 3%. So just little things that are starting to happen in the litigation space on these healthcare bills. Next slide. Okay, so some other less common provider tactics that we see. The first one I have on there is debt set-off, and we're seeing this primarily in Utah and South Carolina. What happens in these cases is there's an administrative procedure that allows the provider to go through this administrative process and then collect or garnish the state income tax refunds. State, not federal. What's interesting about these processes is the legislation, what it permits is the provider to establish a person to sort of oversee this process. We participate in the process as counsel for these plan participants who get a debt set-off letter. And, you know, it's the provider overseeing it, so the provider wins at that level. But the Constitution doesn't allow that to be the end point. So from there, we move into more traditional litigation. We've never had to do that. Once we get involved in these cases at the administrative level, we either settle or get a write-off of that balance. So that is a tactic that we see occasionally come out of primarily those two states. I have appointment scheduling on here. One of the things that we hear is the provider won't see this particular plan participant. And so what do we do? Because they're turning them away, or they're trying to collect a fee up front. How we handle that, we actually get on the phone with the provider. We try to track down who their true provider is, not just the facility or the hospital system or, you know, whoever's making that scheduling decision. We try to get the provider on the phone and talk to them. You know, if somebody is actively seeking treatment and has been and is being turned away, you know, we have the medical necessity discussion with them. We say, look, you've decided this is medically necessary for them to seek the treatment. They're coming to you to seek the treatment. They've already been here 3 times. They need to continue seeing you. And that conversation is, it's rare. I will say, I don't have statistics on this. It's very rare for this to happen from our perspective. But when it does, we get the person's foot in the door with that particular provider, somebody that they have an existing relationship with. If they're trying to schedule and they have an outstanding bill and it's completely unrelated, not determined to be medically necessary or not continuing treatment, we still have those conversations with the provider. We are able frequently to get those scheduled. It is not 100% guarantee that that's going to be scheduled. So sometimes there has to be steerage to another provider. And so that from our perspective, what we're seeing is more often than not when there's already an existing relationship. Again, in the amount of time I've been doing this, and I've been in this space since 2016, I have only had a small handful of these conversations. So it is not something we frequently deal with. I don't know if there's any other comments or questions about that particular component.
Yeah, no, I think that's good commentary, Christine, because it's an objection that we hear from people that are considering adding this sort of product feature on MediShield, meaning they think that, well, if there's a lawyer involved on a balance bill, that's going to just create access problems for that patient. And you know, we can't say that it won't happen, but it's just not that common. You know, it's infrequent.
It is, and I think having a lawyer involved isn't
Right.
necessarily the reason it's occurring, right? Because we're usually talking to the billing department, the finance department, the in-house counsel. They're not talking to the scheduling department.
Right. But I like what, you know, your success rate in terms of talking to that provider and solving that access issue. That's important for people to know that, you know, we are trying to resolve any sort of these issues that do pop up, even though they are infrequent.
Yeah, and I think at the end of the day, what, you know, uh, we sort of see the providers as these big bad providers, but we forget that there's doctors in this and they want to help people. And so if we can play on their heartstrings some, it, you know, that tends to help. So, the last provider tactic, and this is becoming more common, is utilizing the No Surprises Act. And so just a little background on the No Surprises Act. It created essentially a baseball style arbitration process. It only applies to certain bills. Take outside of reference-based pricing. So setting reference-based pricing aside, it's out-of-network bills at an in-network facility, it's air ambulance bills, and it's emergency bills. In the reference-based pricing space, there has been some guidance that suggests emergency bills are the only type of bill in a reference-based pricing plan that would be included under this process. When I look at the legislation, I take a harder stance. I'm an outlier in this. I'll be the first to admit from an industry perspective, but I think from a lawyer perspective, there's others that would agree with me. The legislation does not, in a true RBP plan, does not provide eligibility for this act to apply with respect to the IDR process. There's many other components of it that apply across the board, but what we're dealing with this arbitration process does not apply. So we are now defending these as well. There is no enforcement mechanism under the No Surprises Act for this arbitration process, and that's something that we're sticking to. So we have, for the claims that we have handled, if the award comes out not in our favor, we have many plans who are waiting to see what happens, because it should never apply to the RBP in the first place, certainly not to the out-of-network claims, because there is no network, or the air ambulance claims, again, no network. And so the No Surprises Act has been really a complete mess. There's a huge backlog. There's not very many IDR entities that are trying to handle these claims and clear out the backlog. There's been a lot of stops and starts. So I think there's a lot still yet to be seen in that particular space. But one of the things that we do is handle those IDR claims. That is not on behalf of the plan participant. The plan participant is cut out of that. So this is really on behalf of the plan, which is a little different than what I've been talking about up to this point. But that is out there. You'll see open negotiation notices come in. Some people don't quite know what they are, what to do with them. That is the start of the IDR, that arbitration process. There's a window of time to negotiate, and then everything is very quick after that if that arbitration is initiated. So I think RBP is a spectacular way to avoid the uncertainty of that component of the No Surprises Act. And I have been, screaming that from the rooftops because I think it's this process, this arbitration is so uncertain as to what's going to happen, both with the awards that are coming out. How is it going to, shape the cost of healthcare going forward? Who's taking the hit? Everyone right now is sort of arguing that they're all taking the hit, providers and insurers alike. But I think that we don't have any good data on that yet. So to avoid it as best you can, I think is the way to go. And RBP is the way to do that.
Hey, Christine, a couple comments on this. So, I mean, first of all, would you agree that defending an ER claim, generally speaking, would be easier than an elective procedure, right? Because if it's an underlying contract claim, in some jurisdictions, you'd have a question about, is that a valid contract, or the damages could be reasonable value, for example. But interesting, there's an article that just came out in Bloomberg Law on reference-based pricing. It's not a great article in my opinion, but the thing that I found really surprising is one of the people who were interviewed was a group vice president of public policy for the American Hospital Association. And it's not a direct quote, but the reporter is claiming that this representative said that people in reference-based pricing plans without network coverage are also not protected under the No Surprises Act. And I was surprised to see that. I would, think that they would want to push these into an IDR process, but I mean, we are seeing hospitals try to push RBP claims into an IDR process. So anyway, I thought that was intriguing.
Very interesting.
Yeah, I mean, but it just shows you how much of a unsettled area this is. I mean, there's just opinions all over the place.
Well, and I think when you look at it, when you hear, oh, it helped 11 million, bills, or it kept patients away from having to pay 11 million bills, that's a nice number. But we're really, even if you're talking like a fully insured plan, we're really talking about a small subset of bills. I mean, out of network at an in-network facility. So that's truly a surprise. We often say surprise bill versus unexpected. So a true surprise bill is, I have no idea I'm going to be getting this. My plan has no idea I'm going to be getting this, versus, I didn't double check to see if my guy was out of network or something like that. An emergency bill, if you're going to one of those freestanding emergency centers, that may be more obvious that that's going to happen. Air ambulance may be more, but those are small amount of claims in the big picture.
We have some questions that have popped up around QPA and IDR.
Okay.
And one of the questions is how you determine the QPA. So from 6 Degrees perspective, we pay a lot of money to get access to a third-party database that we would utilize to determine the QPA. And in terms of success rate, and the IDR was another question, which is, I mean, I don't have any exact stats on this. It's been, with the litigation, there's been stops and starts of this whole process, but we have had pretty good success through the IDR process. I mean, it is a waste of time and it's a lot of resources to kind of go through it. So, but I think Christine's approach, you guys are taking the approach that, hey, this is not even within the scope of the act.
Right. So one of the things we're arguing in every one of these, and we argue it both, there's a couple of different opportunities to argue it. One is when we're selecting the arbitrator, we say it's an ineligible claim. We've been successful. So it's marking success is kind of interesting. So we've been successful there in getting the claims kicked, so it never even goes on to the next step. If it goes on to the next step, then it's the arbitrator actually looking at the eligibility and the claims there. And just to sort of give everybody sort of an idea of just how the statistics you're seeing are not very helpful right now. When you go through the process, one of the things that's asked is, what is the QPA? Well, the QPA is populated by the provider when they start that process. And we have had claims that they put the allowed amount instead of whatever they thought the QPA should be. And so they automatically lose because we've already paid what they say the QPA is. And even though it's not supposed to work that way, that's what happens. So there's all kinds of misunderstanding, misinformation as to how the process works. Providers are confused. They're not meeting timelines. So I don't think at this juncture we have enough certainty to be able to say this is the way it's shaking out. Because I'm sure everybody's probably seen the statistic that said 77% of the time providers are winning. And that means, and then the conclusion that that's being drawn by that side of the, of the fence is we're being underpaid. Well, my question would be, how many of those were defended? How many of those did the insurer or the plan actually participate in that process? Because I think oftentimes they don't know what the process is. They don't know how to participate in it. So I think the statistics we're seeing just aren't good statistics right now.
Yeah, I would agree with that. Just from not a lot of these have gone through IDR, so it's hard to draw conclusions from the small end, but it's, we haven't had really bad outcomes in cases that we have gone through that process.
Yep, I would agree with that.
Another NSA question came up, Christine. If I understand correctly, if you take the position that NSA does not apply to RBP, wouldn't it be reasonable to calculate the QPA based on the plan standard MAP %?
Well, so the QPA question is very interesting because, there was a Texas Medical Association challenged the calculation of the QPA, and that case is now up on appeal. I don't think we have a clear guideline as to how to calculate the QPA. When I first saw this come out, I thought, geez, an RBP plan should not even have to calculate a QPA, but they're allowed to use a database. There's the statute itself and the rules that came out outline sort of that methodology. Now that methodology was questioned, so we're going to have to see what the new rules are when those come out. I would say, sure, that sounds good, but the problem with that is the statutes and the rules and regs are actually going to outline the methodology that has to be used.
Yeah, and it's been a while since I thought about this, so I'm trying to clean the cobwebs out here. But if you're taking the position that the NSA does apply to an RBP plan, I think then there's kind of two issues with the QPA. It's like it's relevant for determining what the patient responsibility is, right? Which can be different. It's not saying that the plan has to pay the QPA as the plan benefit.
Right.
So, there's some few things going on here. I mean, if you take the position that it doesn't apply, then, that's a whole nother avenue to go down. But
So, Christine, we're down to 9 minutes. How are we doing on slides remaining versus time remaining? Otherwise, there's a couple more questions that are also.
Yeah, I think if you page ahead, I think this was the last slide, if I recall correctly. Oh, see, questions.
Look at that.
Look at that.
So, one of my favorite guests, Joel, he arrived late. Come on, Joel, you do better than that. But, anyways, he's got a couple questions. I think we may have hit on, but I'll get a little recap time here as we get to the end of this. Any discussion on recent hospital provider tactics of contacting members and denying services unless paid up front, or telling members they are not covered? So this sits a little bit on Christine's side of the table and a little bit on Scott's side of the table. So I'll let you both take a crack at it.
Yeah, I'll add my quick comment and let Christine go. But it's not uncommon for providers to say this, like we've seen in over the years, multiple markets, everything from sending letters to brokers to, making it clear that they don't accept reference-based pricing. And so that's nothing new. But we have to see a hospital actually be able to enforce that policy is more rare. And you don't see very many folks that can enforce that across the board. So, Christine, that was the only thing I wanted to add.
So when we have a member that we're representing that brings this issue to us, and I will say it's a very rare occurrence. I said earlier, I think, I've only had to have this conversation a handful of times, but what we do is we reach out to the provider, the actual, not the facility, not the billing department, but the actual treating doctor, and we have the conversation. If it's a continued treatment, we have an easier time getting their foot in the door to do that. We have not really run into the issue much with requiring upfront payment, certainly not in a scenario where it's continued treatment. If it's new, trying to schedule a new appointment, we will call. I mean, we represent that member and we're their lawyers, and we call and we're not mean and we explain the situation. I know it can sound like, oh, gee, if you're having a lawyer call, that sounds awfully combative, but I think it's really just advocating on behalf of that patient. So, occasionally with new services, we may have to steer or get help from our partners to steer them to a different facility, but it is incredibly rare. And I can remember one time in particular, just, as a little story, there was a person who was having multiple treatments, and the billing department said no more. And I got on the phone with the provider and said, look, you said this was medically necessary. And she went right down there. I got on the phone, she was sitting there, and they took her that day and got her the treatment that she was supposed to have. I mean, there's the physicians do have a heart, right? They want to be doing what they're doing. They want to treat these people. So we've got that going for us. But also, if they've determined it's medically necessary and then they're going to turn them away, that can be a problem. So there's sort of that working too.
Hey, Scott, you probably see Joel's commentary here. I mean, as you pointed out, it's a tactic that we see from some of the providers out there to create access issues, to create fear. Very little typically comes of it. And as you're seeing, as Joel's comments, that they still directed their individuals to go to their appointments, and looks like most of them got in. But anything you want to add to that?
Is this Joel from up Washington?
Yep.
Yeah. So, the Northern Washington market there are some providers up there that have been pretty aggressive recently. And so, I think this gets at you can find these anomalies in certain markets when you get a provider that is going to try to really cause trouble for a reference-based pricing plan on an access basis. And so unfortunately, Joel is experiencing that firsthand with his members. But it is a challenging situation for sure. But I think if it's tied into a balanced bill situation, like with MediShield and Christine's involved, frankly, lawyers do have a little bit more leverage with providers because it's just there's that threat of litigation there, and so if it's outside of that context, it can be a little bit more challenging. If you think about your options on an elective basis, obviously they can't do this in an ER setting, but on an elective basis, it does come down to, are you going to be able to convince them to take them, contract with them, or find an alternative provider? And it's just very nuanced, very market specific, what kind of competition and control the health system has in a particular market.
All right, we're running out of seconds here, but Christine, there's a comment / question that came in from Mike. I have several plans who calculate the QPA at their standard 140 and take a wait and see approach on IDR. Until IDR, the potential difference between the standard QPA or the settlement amount and the MAP is the plan's pocket. Would you support this approach?
I support the wait and see approach. I'm not sure forgive me, I'm not sure I'm fully following the second component of that. I think if it's an RBP plan, my approach to it is, with the IDR process, is yes, take a wait and see approach. Well, what we do when we get involved is we actually send a letter back or have a conversation with that provider in response to the open negotiation notice. One, because it feels like the right thing to do. Two, we want them to know where we stand and what our arguments are so that they know that as well. But then if, they're not willing to just go away on it, then yes, we take a wait and see approach. And if IDR is initiated, then we trot out our same defenses for that, and challenge the eligibility, among other things, but challenge the eligibility of it too. So yeah, I think a wait and see approach is kind of what we're doing. Wait and see if it's initiated. If it's not initiated, then great, that bill basically goes away. They don't think they can collect it against the plan participant, and the plan hasn't paid anything.
Where do you think this is going to go enforcement wise?
They're going to have to go back to the original legislation and create an enforcement provision. And I don't know that that'll get done. That or the courts are going to have to determine what the enforcement, but that's not going to happen either. So, we're seeing these enforcement cases with the Cigna, Aetna, the bigger multi-million-dollar payments that haven't been being reimbursed. And there's just been no enforcement yet. So I think for us, the type of plans that we're handling, it's not going to trickle down to us for a very, very, very long time, if ever.
Maybe it depends on who's elected president next. We'll see.
Could be. And the Senate and the House. Gotta all be, so we'll see.
Well, thanks for your time, Christine. I know
good stuff.
Taking time out of your spring break with your kiddos, so we really appreciate having you.
Yeah, absolutely. This has been wonderful. Thank you, guys.
Yeah.
Appreciate it very much. Yeah, let's close this thing up. To the audience, thanks for joining us once again. We'll have an April Fireside chat. I think if we got one more slide to go, do we have it on here? No, you can always see our recordings through that link. So if you go to our website, you'll find that. And Danielle, we got the next April guest on here. Perhaps not. Sounds like Ryan Works can be joining us in April. So look forward to having him on. Always entertaining and a nice political view of the landscape back in Washington. So to that, enjoy your afternoon. We'll see you next month. Take care, everybody.
Thank you.
Bye, everyone.